Do you need an estate plan? Not sure? Don't know where to start? You're not alone. The legal process can be intimidating, but it doesn't have to be. Joining me now to help us better understand what we need to know is attorney Melanie A. Essary with Essary Law Firm. Thanks for being here.
Thank you for having me.
Well, I know this is kind of confusing for some people, and it's something that we really don't like to think about a lot of times, but it is obviously really important, as you know. First of all, who needs to think about an estate plan? Is this something only for people with considerable sums of money, or is it something we all need to think about?
Well, you know, that's a very common misperception. People hear the word estate plan and they think, I don't have enough money, I can't possibly need an estate plan. But really, anybody needs an estate plan. Anybody who has any assets, especially assets that are titled in their name. Think of a car, a house, a bank account. These are all things that are going to have to go through probate. In order for them to go through the probate process, you have to have a, well, you don't have to have a will, but it's beneficial to have a will to ensure that the property goes where you would like it to go.
Now, you mentioned a will. I know in estate planning, and I saw on your website there was a lot of good information. It was talking about some basic documents that would be included in an umbrella term of estate plan. Tell us about those basic documents that would be part of that plan.
Okay, well, a basic plan, it can include a trust. Some people want a trust, some people need a trust. That's really an individual decision for the person or the couple who's making that choice. But at a minimum, it should include a will. This is the document that tells the court where you want your property to go to, who you want it to go to, when you want it to go to them. It should include a power of attorney. This allows somebody to step in and help take care of your financial affairs should you not be able to do so for yourself. It should also include a healthcare surrogate. A healthcare surrogate allows somebody to step in on your behalf and make healthcare decisions for you, again, should you not be able to do so for yourself. And the important thing to note about a healthcare surrogate is that healthcare surrogate can never override your own decisions. If you're conscious and able to make choices and speak to the doctor coherently, that surrogate is never going to override your opinions. And the final document is a living will. This is the document that covers what happens and what your desires are should you have a terminal condition, an end-stage condition, or end-stage renal conditions.
Okay. Well, let's talk about some of these terminology that kind of compare up. What's the difference in a will and a trust?
Okay, the difference between a will and a trust. In a will, you maintain ownership of all of your property. And in the will, you simply tell the court who you want your property to go to. In a trust, you transfer all ownership of the property to the trust. And then you, through the trust, you would be known as a trustee and you would control the assets as the trustee. Then upon your death, you would name a person to act as trustee after you, and that person would take care of transferring the property instead of the court.
In a short form, if one is possible, what's the main pro and con?
The main benefit to a trust is avoiding the courts and the probate administration and the cost of the probate administration. Now, the downside is that you always have to maintain ownership in that trust and everything has to flow through that trust. So it may not be quite as easy for some folks to handle.
Okay. Now, what about in the state of Florida if someone passes away without a will?
If somebody passes away without a will, and you may have caught that earlier, I said you need a will to go through probate administration, but you do not. What happens without a will is what's called intestacy loss. There are very specific statutes in Florida that deal with what happens to property when somebody passes away without a will. And they're very specific rules and they're very complicated rules. So anybody who wants to know what would happen to their property in the event that they pass away should really consult an estate planning attorney.
Okay. So if you want to have a say, you need to get
you
one of
need
those
to
two
have
documents
that will.
that you talked about. Well, you mentioned power of attorney. I know there's a durable power of attorney and just a general power of attorney. What's the difference there?
The difference between a durable and a general is the durable maintains effect, and that agent can still act in the event you're disabled or in the event you're incapacitated, with the exception of if a a court action is started to determine whether or not you have been incapacitated to put a guardianship over you, then that power is suspended for that time being. Now, that's not to say the court can, once that process is completed, the court can determine that power of attorney can stay in full effect or limited effect.
Okay. Well, in both cases, it sounds like they're making decisions for someone, so that's kind of what I understand that the healthcare surrogate does too. So how do they compare? Is the power of attorney a more general decision-making ability where healthcare is more related to healthcare?
Power of attorney, the durable power of attorney is limited to your financial affairs.
Okay.
The healthcare surrogate is limited to your healthcare affairs. The guardianship proceeding, if a guardianship proceeding is begun, will control everything. It can control both or one or the other. But it's an all-encompassing procedure, and it's meant for folks who really are at the point where they cannot handle their own affairs. Think of folks with Alzheimer's or advanced dementia.
Well, let's talk about a living will. Some people may think, well, I've already kind of made my wishes known or provided some instructions, but how does that fit in? And what if can you have a living will, but you still need a healthcare surrogate? Talk about this if you don't mind, please.
You really need both. A healthcare surrogate is broader than a living will. A living will is strictly the document where you get to say what happens to me and what do I want to happen if I'm in an end-stage condition. Do I want them, providing me with every possible means of health care to keep me alive, or do I want them to allow me to pass away easily? A healthcare surrogate is much broader. A healthcare surrogate allows somebody to make any decision for you, not just end-of-life decisions.
Okay. Well, we're about to run out of time, and I know this is a very deep subject, but what are some very common questions and concerns that clients come to you with?
Probably the most common question is, do I need a trust or do I need a will? And that's going to be an individual decision. I sit down with my clients, I let them know the pros and cons of each, and I let them know that it is completely up to them. Probably the other real general question for me is summary administration. A lot of folks are interested in summary probate administration because it's a much easier process to go through than full probate administration. And that I have more information on my website. It's again more complicated, much more complicated situation.
Do you find that people typically come alone or with a spouse, or sometimes do you have families that come together?
I often have people come with their families. If a husband and wife are doing it together, they obviously come together. But even the single folks that I have widowed, they typically will come with family.
Okay.
It's, I think, a situation where people want the comfort of their family.
Sure, and everybody does need to know, and it just kind of makes things easier on everybody emotionally during a very hard and trying time as well.
Exactly.
Well, thank you for the great information, and I'm sure people can find your website. But what is your website again now?
My website is PensacolaWills.com. So www.pensacolawills.com. If you don't have access to the internet, you're more than welcome to call me at 850-343-9999.
Great. Thank you, Melanie. I appreciate it.
Right, thank you.